Okay, let's dive right into this explainer and unpack exactly how civil litigation costs work, and more importantly, what happens when the lawyers themselves are forced to foot the bill. Today, we're looking at a fascinating and honestly kind of terrifying area of civil procedure. We're going to examine a master essay on solicitors' negligence and costs, specifically focusing on a 10-case review that really reveals the harsh realities of legal practice. It brings up a really high-stakes question. What happens if a solicitor brings a case that legally shouldn't even exist? We usually think of lawsuits as this strict battle between the plaintiff and the defendant. But there's actually a hidden third dimension to this whole battlefield. When exactly does the court look right past the arguing parties and point the finger of financial liability directly at the legal representatives? So here's our roadmap for today. 1. The golden rule of costs. 2. When the winner pays. 3. Liability for wasted legal costs. 4. Suing for invalid clients. 5. Unmaintainable and careless claims. And finally, 6. Calculating the final bill.
All right, Section 1, the golden rule of costs, understanding the foundation. We really can't appreciate the plot twists until we understand the basic rules of the game.
So, in civil litigation, the word costs actually refers to two totally different things. First up, you have solicitor and client costs. This is just the standard contractual fee you agree to pay your own lawyer for their time. Second, you have party and party costs. Now, this is the amount one litigant pays to the other to compensate for the hassle and expense of the lawsuit, and it requires an actual court order. It's absolutely crucial to understand this distinction because getting the other side to pay your party and party costs rarely covers the total solicitor and client bill you owe your own lawyer. Actually, scratch that. Even if you win, you might still end up out of pocket.
As established in our first case, re Elgin Limited, the general rule is that costs follow the event, which is basically a fancy way of saying the loser pays the winner. But, and this is a big but, that is entirely at the court's discretion. The court established that while the loser typically pays, this doesn't apply if the successful party acted improperly or unreasonably. If you win, but you caused a massive, unnecessary circus that dragged out the proceedings, the court can literally deprive you of your costs or even make you pay a portion of the loser's costs.
Moving right along to Section 2, when the winner pays, plot twists in procedure.
You see, the court is actively watching how you play the game, not just whether you win. The golden rule gets thrown out the window in several specific situations. The court might order each party to just bear their own costs, or, shockingly, order the winner to pay the loser. This happens with illegal contracts where both parties broke the law, or when there's gross misconduct, or even if you just fail to cite previous legal cases that would have saved everyone a bunch of time.
These next two cases brilliantly illustrate this. They show how failing to cooperate, or simply skimping on your legal research, can cost a winning party everything financially. In Case 2, Chen Chao-lek v. Tan Yu-lei, the successful defendant had to pay the costs of the appeal and the trial. Why? Simply because their incredibly uncooperative attitude forced the plaintiff to take action in the first place. And in Case 3, Re Syed Al-Sagos, the appellant won the appeal, but got absolutely zero costs because they failed to cite two highly relevant cases at the initial trial that would have won them the case right then and there. Basically, the court flat out refuses to reward inefficiency.
We also see the court stepping in to protect parties from unfair surprises. In Case 4, Anna Zhang Yu-hyung, the appellant, won their appeal, but solely based on a brand new point they hadn't even bothered to raise in the lower court. The penalty for that ambush? They had to bear all the costs of the appeal. Plus, when a plaintiff is forced to sue multiple defendants because they are all just pointing fingers at each other, which we see in our 5th and 6th cases involving Bullock and Sanderson orders, the court can order the losing defendant to pay the costs of the winning co-defendant. It's a neat way to ensure the innocent party isn't left holding the bag.
Okay, on to Section 3, liability for wasted legal costs, the crosshair shift. This is where things get really intense. Under Order 59, Rule 6, if costs are incurred improperly, without reasonable cause or wasted by misconduct or undue delay, the court can make the solicitor personally liable. The protective shield of professional representation completely falls away. The court suddenly has the power to disallow costs between the lawyer and their client, direct the solicitor to repay their client, or even direct the solicitor to personally indemnify the opposing side. But the system does mandate procedural fairness.
A lawyer won't just be slapped with a personal cost order without first getting a chance to defend themselves. Under Order 59 Rule 6, Subrule 2, the solicitor must be given a reasonable opportunity to appear before the judge and explain why such a heavy penalty shouldn't be applied. They might even invite the bar counsel to attend so that disciplinary action can follow. It's a whole ordeal.
Let's look at Section 4, Suing for Invalid Clients, Breaching the Warranty of Authority.
In both of these absolutely astonishing cases, the solicitors were held personally liable. Why? Because by acting for clients who lacked legal standing, they breached what's known as their implied warranty of authority. In Case 7, Mahad Yusuf bin Awang, the lawyer sued on behalf of a bankrupt person without getting official sanction. And in Case 8, Simmons v. Liberal Opinion Limited, the lawyer was defending a newspaper company that literally hadn't been legally registered yet. When a solicitor steps into court, they are effectively guaranteeing that they have a valid, legally capable client. When that turns out to be false, the solicitor pays for all the wasted time and costs.
But honestly, the most terrifying scenario for any practicing lawyer is Case 9, Young v. Toynbee. This case proves that you don't even have to be malicious or strictly negligent to be held personally liable. Just look at the facts here. A defendant instructed a firm of solicitors to defend him in a libel action. But unknown to the solicitors, shortly after giving those instructions, the defendant was certified insane. The solicitors, totally unaware, continued to take legal steps on his behalf. Months later, when they finally found out, the opposing side demanded the solicitors pay all the wasted costs. And the court actually agreed. Even though the solicitors acted completely in good faith and had absolutely no idea their client had lost capacity, they still had to pay the opposition's costs out of their own pockets. It's incredibly harsh. The warranty of authority is strict. Good intentions won't save your bank account.
Section 5. Unmaintainable and careless claims, the ultimate penalty.
In our 10th and final case, Karpal Singh Varatip bin Ali, the judge really didn't hold back, using this scathing language right before rejecting the lawyer's excuses. A defamation suit was filed against the defendant for allegedly defaming a political branch. The problem? The suit had absolutely zero valid cause of action in law. It was completely dead on arrival.
The crucial point here is that the court uses personal cost orders as a weapon to maintain high professional standards and stop baseless litigation in its tracks. In Karpal Singh, after rejecting the lawyer's explanation, the judge ordered the lawyer to personally pay up. The court's main priority is protecting the innocent opposing party who was forced to spend money defending against a lawsuit that any competent lawyer should have known was conspicuously unmaintainable.
And finally, Section 6. Calculating the final bill. Standard versus indemnity.
The contrast here is massive. When a court orders costs, it has to decide how to calculate them. The standard basis is the default for party-to-party costs. It allows a reasonable amount for costs reasonably incurred. But here's the kicker. If there's any doubt about whether a cost was reasonable, that doubt is resolved in favor of the paying party. On the flip side, the indemnity basis, which is often used for solicitor-client costs or as a punishment, allows all costs unless they are explicitly unreasonable. And any doubt? That's resolved in favor of the receiving party. The indemnity basis is a much, much heavier financial hammer.
But how does the registrar actually decide what is reasonable during this whole process? Well, they apply the test of a sensible solicitor sitting in their chair, assessing what was reasonable at that specific moment in time. They don't use 20/20 hindsight. They look at the facts exactly as they existed when the lawyer made the decision to incur that cost, regardless of how the case ultimately turned out.
So, after seeing how easily a solicitor can be held personally liable for a client going insane without their knowledge, or for bringing a suit deemed unmaintainable, it really leaves you wondering, are these rules the perfect safeguard for the public, or are they a perilous trap for legal professionals? It certainly makes you view the phrase, "costs follow the event," in an entirely new, much more complex light. We've barely scratched the surface of civil procedure today, but these 10 cases definitely prove that in the courtroom, absolutely everyone is accountable. Thanks for joining me on this deep dive into the source material. Catch you next time.